Court handed down an historic decision this morning, ruling unanimously that the First Amendment does not apply to Tom Becker of Phoenix, Arizona. For more now, we're joined by Onion News Network Washington correspondent Jane Carmichael. Jane, obviously an unprecedented decision here. Take us through the timeline.
Well, the class action lawsuit was brought before a Ninth Circuit judge by a coalition of Mr. Becker's co-workers, neighbors, and family members who said his continued right to free speech was causing them emotional distress. They presented several videotapes of Mr. Becker to the court as evidence.
Well, let's take a look at those now.
I had to wait at the airport for 6 hours. Do you understand? This is back when I'm running my real estate business, so every minute I'm there, I'm losing deals.
Oh, yeah. I'm a huge motorcycle guy.
Mold spores get in your lungs, you're dead. That's why I always say, I will never live in a house with carpeting.
Now, Mr. Becker himself testified before the Supreme Court yesterday, right?
Yes, and according to sources close to the court, that was really what solidified the court's decision. Mr. Becker delivered a rambling 3-hour testimony in which he digressed into a pointless 45-minute story about moving a washing machine by himself, his opinion that organic food is a ripoff, and multiple remarks about the Supreme Court's chambers not being as, quote, classy-looking as he assumed they'd be. He said several times that he had stayed in hotels in Las Vegas that were way nicer.
Yeah.
Following that, the decision to remove Mr. Becker's First Amendment right took only about a minute and a half. In his majority opinion, Chief Justice Roberts wrote, the only feasible options facing this court are to revoke Mr. Becker's right to free speech or legalize murder so we can beat him to death with our gavels right now.
Totally understandable. And then they went with that first option.
They did, that's right. And Mr. Becker may now legally speak aloud only after writing down what he wants to say and having it approved by an independent arbiter.
All right, Jane Carmichael, thank you for the update. And keep your head up. You're doing a really, really great job out there.
Thank you, Brooke.
Analysts expect this ruling could be the first step towards a nationwide requirement that Americans undergo a 5-day waiting period before uttering an opinion of any kind.
So we're getting going on another week. I am really kind of not too tired. We're shooting this on a Wednesday in the middle of the week, so feeling a little groggy, but this has been a couple weeks since I've actually shot something, so I figure I might as well just get ahead of it. For you guys, this is about your 7th week, I think, of class already, so we're getting into the real middle of the semester. You just had your first unit test. Hopefully that went well. I don't know. We'll see. But this is now where we get to the 3 branches of government that we're going to be talking about. I mean, this is literally what all government classes are usually based around is these 3 branches. So I really like doing a section just on them because it's so important and we can really focus in on these 3 branches and what they mean to our government and why they are so important. For the judicial branch, most people when they teach a government class do this one last, and I think a lot of it is because the judicial branch is misunderstood. I really like talking about it because it's really one of the few things that the founding fathers in the Constitution did not know really what to do with it. I mean, for a lot of this, they were kind of guessworking. Like for the executive branch, they knew they didn't want to give it a lot of power, but they knew they had to give some power. For the legislative branch, they knew that that's where they wanted the power to reside and how they wanted to look and the powers they wanted to give it. They gave a lot of information about that. Even in the amendments, they knew the process of the amendments. In the state rights stuff, they knew exactly how they wanted to lay that out. In the 6th section of it too, they knew the debts and the supremacy clause, all the stuff that they kind of knew. The 3rd section of the Constitution, which talks about the judicial branch, really is kind of wide open. They didn't know what they wanted out of this. So that's why I find it so interesting and fascinating to talk about because this is really a self-made branch and something that up until this point, they had tried at least strong executive branches, which were really just monarchies, and that was kind of new, but for the most part, they've tried this strong sort of government central role. For legislative branch, I mean, there was parliament and things like that had come before it. So they kind of had precedent of what they wanted to do with that. There had never really been an independent judicial branch of a government. All judiciaries had really derived from kings. So this was brand new for people to try. And I really like talking about it first because I think it doesn't get enough attention. And it is the branch of government that does not see the most light of day, partially by design, but also because I think a lot of people just misunderstand it and think it's complicated and confusing, and some of it is, but the basics of it is what people should understand, and that's what we're going to go over today. We're just going to lay out the basics of what this thing is and why it is so important to our process. So in order to begin talking about the judicial branch, we need to talk about the concept of justice and what that is. I mean, this is literally what our whole system is based off of. And justice usually comes from the idea that the strong usually win. No matter what, in any society from the time that we've been alive as human beings, the stronger of us usually survive, and justice is what will come. In society, money can buy justice too. I mean, this is just a pure fact. We've seen this plenty of time in our justice system, that a lot of money and wealth and power can buy you good lawyers and better researchers and all these things that can help you win a case. You just need the people behind you and backing you to really win that case, and people with a lot of expertise. In the law, the better brief wins, meaning that when you have a case in front of you, the one who's probably going to win is the one that has the most succinct, most effectively argued briefing. And it's a really hard skill to hone, but this is usually what wins in the law. And justice is usually defined, the actual term of it is defined as the maintenance or administration of what is just, especially by the impartial adjustment of conflicting claims or the assignment of merited award or punishments, the determination of rights according to the laws of equity, conformity to truth, fact, or reason. The law is made to bring people back to wholeness, or to hand out punishments, and making sure people are whole as much as they could be, at least under the eyes of the law. And this, it also means to do justice, to seek justice done, and to summon one to justice. The ideas of justice really are a basic human concept that really we as people are looking for, to make things right and make things whole again too. That the justice system is there to be the balance for what things we have lost or things that we want to put into place. Justice really started from the ideas of, like, even from the clans and tribes of our ancestors. I mean, really, like, the ideas came from the very basic concepts of human nature. Tribes and people began to form around different societies, and societies began to set laws in place in order to make sure people were safe. And from those tribes, it would come to villages and to cities and to nations eventually, but it started from these very grassroots concepts of what justice is. And it was always about what was right versus what was wrong. There's really what that comes down to. Justice is about the right and wrong of something, even though it might not be right for some people under the eyes of the law. It is what it is, and people kind of accept it as that. It derives from a very religious background. I mean, the Old Testament lays out the Ten Commandments, and that is really kind of the first, or at least some of the oldest established laws that were put into place. The Quran also lays it out, and the Bible just in general also lays out very distinct ideas about what is justice and law and what is right versus wrong. And religion plays a huge part into that, because as people, as we've evolved, religion has been a huge part of trying to bring the ideas of right and wrong into our morals, into who we are as people. The Romans were really the first to come up with this concept of that the civil authority of the nation ruled supreme over everybody else, and that the civil authority were the ones who would bring balance to what was right and wrong. The Romans were the first to kind of put in these huge laws that, beyond just like a religious scope, were part of like a civil society. So it was not just a religious thing where religious leaders were leading it. It was a civil authority who had the right to administer justice and administer laws. And this is also built off of British law as well. British law set the idea of precedent in the law. And precedent becomes a huge part of the Supreme Court, because when you have precedent in the law, you usually follow what has come before you. That the ruling of the judges in the past affect how you rule on things in the future. That means laws build on top of one another in other court rulings. So when a court sees something handed down from the Supreme Court, another lower court must follow, or usually will follow, the rulings of that Supreme Court. Like, let's say there's a case that follows that sort of precedent in rulings. That's why people look up prior cases, and why lawyers, usually a lot of their job is just looking at prior cases, things that have set precedent before in similar cases to what they are arguing, and bringing them to a judge and saying, hey, this is what has been told before, or told to a jury too, that these rulings, this is what happened, and these are the things that had come before that we didn't set into place. This was something that prior judges had. So it's trying to build on top of the law and not just completely write new ones all the time. So you have to set precedent, and British law is what really set that into motion and becomes super important to our laws as well. So there are 6 kind of stages to the evolution of justice. First is what we call brute strength. So that really came from the thing that we talked about with tribes and clans. That came from the idea that the stronger usually wins, is what we said before. But That was the first step in the evolution of justice. The second one was natural law and how things should be. So the ideas of nature and what man is, we kind of established this ideas of right and wrong. And that was just based on the natural order of things and how we viewed them as human beings. The third one was Greco-Roman, British, and French lineage of law. And so that's what we talked about, the ideas of absolute civil authority and the authority of the government being able to carry out laws that aren't directly connected to a religious order. There was also the fourth step, which was basic law, and that was existing law that was written down. Writing down laws and having laws written so people and average people could go and look at them. If people knew their rights or what the laws were, it made society easier to run. If you just had people who didn't know what they were talking about or had laws that they broke frequently because they didn't know what they were, the ability to write down a law made a huge difference. There was statutory law as well, which was Roman, and that came from the law of the legislative body. That is, laws that were handed down and made by an established body of authorities who made their own laws, and there was nothing based in a religious order, but the ideas of what was good for the society. And that's what laws began to build from. And then the last one is common law, and that's the interpretation of the law from things that have come before it, and interpreting what laws mean or what the founding fathers meant by certain constitutional order, or trying to figure out how things are presented that build on top of the other laws. So again, common law is that building and setting precedent of the law. The last thing we're going to talk about for the introduction is just the general functions of law. So the first is conflict resolution. Most court cases or civil cases, especially from what you see on many TV shows, comes from the ideas of conflict resolution, that there's a conflict between two parties and that the court is there to decide how they're going to resolve that conflict. And that could be any little thing between divorces to a big stuff, which is like big corporations trying to settle disputes between their own multi-billionaire, attorneys and or individuals. It can be a really good way to make sure that conflict is solved from a certain standpoint. It also provides social order, that we provide law and order. I mean, again, TV show as well. That same idea of that law is there to establish order. If people follow the laws, then they really have nothing bad happen to them. If people break the laws too, then it's the job of the law to bring them to order and to either put them in prison or to fine them or to do whatever they need to do to make sure that society is functioning orderly. It's there to also protect against regime limitations, that the court is there to block different things from the legislative and executive branch and be the counterbalance to certain things that they might do that might overstep their powers. And the court can look at everything that they've done, and we'll talk about the ideas of judicial review and the importance of balancing the regime that is in place and not letting them get too powerful or get away with things that could be unconstitutional. There's also the protection of rights and the protection of rights of citizens, that the court is there to make sure citizens always have rights under the law and that they, under the Constitution, they are given those rights and given a platform for those rights. It's the job of the court to make sure that people are given a safe space, that they feel like they are protected, and that even if something does happen to them where their rights are infringed upon, the court will make it right and make them whole eventually. And the last function is it provides a place for public policy. Again, writing laws and participating in laws is a form of civil order and also making sure that people live a happier life too. The court rulings on gay marriage were a huge step for individual gay people who really saw their quality of life pick up because they were able to get married and able to have that really essential function of some societies, that they could get married and could live with one another. And that was a really important thing. While the religious aspect of it, maybe some people might disagree with it, the ideas of the law and being equal under the law, this really made a huge new public policy, and it created a standard for every state. And it's insane to think about that, but it is a place to make public policy as well. And the court is sometimes the moral authority for our government, where really the change that happened from the civil rights movements, Brown versus Board of Education, was a public policy move as well as a protection of rights for citizens. So it functioned almost in two ways. So now we're going to talk about the actual function of our U.S. system and what it actually does. So Article 3 of the Constitution is what lays out the general powers of the Supreme Court. And it has original jurisdiction over almost all laws of the United States. But that was really kind of hazy And the Constitution didn't really lay out those powers or what they were, because honestly, the Founding Fathers looked at it and said, I don't know what this is supposed to look like. So they kind of just let it grow on its own. They had jurisdiction over the cases under the Constitution, the laws, and the treaties. They had maritime jurisdiction as well. So if there was something that they needed to decide on for maritime law, that would fall under their jurisdiction. They would also be able to preside over any cases where people were suing the United States as government as a whole. So the U.S. government could be a party in a case. And that was the power of the judiciary, where somebody could sue the actual government. They would also be the place where two states who were suing one another could come and resolve it's a conflict resolution. It's two states who might have a conflict between one another, and they would go to the Supreme Court to decide on that case. It would also be the place where citizens between two states would come, or more states maybe, not just two, but if there were two butting heads from different states, two citizens who were butting heads, the Supreme Court would be the place where they could go and settle their claims as well. And it wasn't just the Supreme Court, I shouldn't say that, it was also the entire federal court system, that they could go to that federal court system and be under that jurisdiction. So they're not automatically getting the Supreme Court, and we'll talk about why that is. They also could be the mediator between controversy between states or the citizens thereof, or foreign states or citizens thereof. So this would be the place where people could come and sue from states or citizens in this country who were suing foreign states or suing foreign citizens of other states as well. And it could also be the places where it was affecting ambassadors or public ministers, anything that had a public atmosphere to it or was a representative of the U.S. government. This would fall under a federal jurisdiction. And the Judiciary Act of 1789 is what set this really into motion. This is one of the first things passed under the Constitution, and it established a three-tier court system. That was the U.S. Supreme Court, that is the big, tall one that we all know. Then there's the U.S. Circuit Court of Appeals, which there's a lot of different court of appeals over the United States and different court systems that we fall under. I think there's like 12. The U.S. District Courts as well, which we have one in Sacramento. We have the federal courthouse in Sacramento, and that federal courthouse falls under federal jurisdiction. Now, it builds up to a certain point where you would have to start in the U.S. District Courts first. If you lost your case, you could appeal, and if that appeal case went to the Supreme Court, it could go all the way up to that Supreme Court, and you could ask the Supreme Court to look at your case, but they might not hear it. They might just take the rulings of the appeals court or the U.S. District Court. And most state court systems follow this model, too, where it's the state Supreme Court, the state Court of Appeals, and Superior Court. So we have Sacramento County Court, that's also in downtown, but that is different from the federal courthouse that is right near the train station, and then that's different from the county courthouse, which we also will follow. So it depends on what laws you break that you might go to that court system, or it depends on what jury duty you might get. That might be a better one. You might want to get get jury duty compared to actually breaking a law. So the history of the early court was really not kind to the Supreme Court at all. The first couple years of this thing, they really did not know what to do with it. It was pretty poorly received that this independent judiciary really had no power. People didn't know what to do with it. The vagueness of the court system was really a problem because all these two other branches really had their things figured out. The Constitution really laid things out pretty clearly, and you had pretty strong people in the legislative branch, and also George Washington, the executive, who really made sure and had this vision about what their two branches of government were going to be like. Really, nobody wanted to serve on the Supreme Court when it first started, and John Jay refused to be Chief Justice, and he was seen as weak, and it floundered until 1801, and John Jay was the first Chief Justice of the Supreme Court. It really wasn't a job that he wanted or desired at all, and it floundered for 12 years almost under this new system until 1801. This was a big argument that they had in the Declaration of Independence, saying that the judiciary was too attached to the king. And the Federalist Papers even laid out the ideas that the independent judiciary were so important to counterbalance the other branches of government and make sure that they become too tyrannical also. So you had both sides of the aisle, really, from the Declaration of Independence, which was written by Jefferson and pretty anti-federalist, to the Federalist Papers arguing that they should have something that is independent on its own. And it became a huge issue that this was an important declaration of the Declaration of Independence, that they wanted a strong independent judiciary that was not attached to any of the other branches. And it wasn't until the Marshall Court where it really became different. The Marshall Court is very, very important for the establishment of the power of the judicial branch. And it was this man, John Marshall, who became the fourth Chief Justice of the Supreme Court, who really established the ideas of the court. He was appointed by John Adams, and he served all the way from 1801 to 1835. And he served a long time, especially for that. It was 24 years where he really was able to establish himself in this Supreme Court role. John Marshall was a huge proponent of the ideas of Alexander Hamilton, and he read the Federalist Papers and knew how important that a strong federal government was and how essential of a role a strong Supreme Court would play in making sure that government stayed afloat. And he really made sure that the court had one cohesive voice and was equal to that of respect. If they had one cohesive voice together, they could make decisions all together as one voice and one branch instead of a number of different people saying different things. He discontinued the ideas of seratium, which means that there wasn't just a series of opinions that judges would put out. So in most court cases, at least now, the way it's established, and we'll talk about this in a little bit, is that there's one person who talks for the side where they have decided on a Supreme Court case, that they're in the majority. And then there's another one that is dissenting, and that's the minority ones, the ones who lost, but they explain why they voted against something. And the other side explains why they voted for it and why it's important. And instead of just having those two opinions, the way the courts used to work was they just have every single justice put out their opinions on the case. And it became too cluttered and became too many voices talking at once. So Marshall made this idea of, hey, why don't we just have one person speak for all the people who voted yes on this thing, and we'll have one person speak for those who said no. And that way the American people can decide on what they believe in. And this was a really great way to just make sure that there was one powerful voice in the judicial branch, and that there wasn't just a bunch of different things that people were saying all at once. And you've probably heard of this court case before, but Marbury versus Madison was a huge issue that was a huge court case that established all these ideas of the Supreme Court and how we know it today. And that's the ideas of judicial review. And to be very brief on explaining how Marbury versus Madison worked, it basically was this huge issue between the incoming president, Thomas Jefferson, and the leaving president, John Adams. And again, they had their own issues as it was, but they really had this huge final argument before they left. And Adams had lost the election of 1800, and in March 1801, he was just 2 days away before his term ended as president, and Adams appointed several dozen Federalist supporters to new circuit judges and justice of peace positions in an attempt to frustrate Jefferson and his supporters in the Democratic Republican Party. And the U.S. Senate quickly confirmed Adams' appointment, but upon Jefferson's inauguration, the new judges' commissions had still not been delivered. And Jefferson believed the commissions were void because they had not been delivered on time, and he instructed his new Secretary of State, James Madison, not to deliver them. One of the men whose commissions had not been delivered was William Marbury, a Maryland businessman who had been a strong supporter of Adams and the Federalists in 1801. After Madison had repeatedly refused to deliver his commission, Marbury filed a lawsuit to the Supreme Court. And this court case began to lay out the ideas of, okay, what does the Constitution actually mean? Is it just a statement of principles, or is it actual law? And this established, and the ruling by John Marshall, he wrote that it actually was the job of the U.S. Constitution and of the judicial branch to uphold the ideas from the Constitution. So there were a lot of opinions that came from Marbury versus Madison, but the most important one came from the idea that the Supreme Court has jurisdiction over the matter, meaning that they could look at an issue in the federal government and could decide and really make sure that they could review everything that the federal government had done if they find that there might be an issue. Marshall ruled that American federal courts have the power to refuse to give any effect to congressional legislation that is inconsistent with the interpretation of the Constitution, a move known as striking down laws. So the court had the ability to strike down a law that it felt wasn't upholding the Constitution, and it was the job of the Supreme Court to decide what the Constitution was saying. And looking at the Constitution and looking through the entire thing and knowing that this doesn't uphold the values that we have as the Constitution and also doesn't uphold the law. So after this, Marbury versus Madison really laid out the ideas of judicial review, and the Supreme Court made its own power. This is not laid out in the Constitution, but this was laid out in the court itself. That's why it's so interesting, because this never would have happened if that court case had not been decided on. We would have had a very weak court system. And it was so crucial to have John Marshall in at that time with that court case. And I guess how lucky it is, too, that the Supreme Court has the ability to check on the things that the rest of the federal branches of government do. And this is extremely important in making sure that they have that ability to check on laws and strike them down if they feel like they need to. So now we're going to go over the process of actually how does a court case make its way to the Supreme Court and what does it do, and a couple other things as well. We're going to go into categories of law, how you make an appointment to the Supreme Court, and then hearing a case and what that internal process is like, and then how they put out an opinion on each court case. So the way that cases work their way up is they go to trial courts, appeals courts, and then to the Supreme Court. So for most federal court cases, if something happens in the federal court system, it starts at the lowest level. And again, that courthouse that I talked about in downtown Sacramento is a good example of the lowest form of the federal court system. That is the trial courts. Put up a map on the screen so that way you guys can see what the appeals courts look like and the jurisdiction that falls under each of them. There are 13 different appeals courts, and you'll see them all over the map. We are currently in the 9th appeals court district. So this spreads all the way from Montana all the way to Arizona and the rest of the West Coast, including Hawaii and Alaska as well. If there's a federal trial that you feel like let's say you were in it, hopefully not, but let's say something happened in the federal court, you could go to federal court too. If you were not satisfied with the decision, you could go to the appeals court, and that would be the 9th Circuit Court of the appeals. And if they found something as well that you didn't agree with, you could then go to the Supreme Court as well. Filings. So in federal court, there's almost 29,000 court filings a year, and that's across the United States. That has a lot of court cases, and that's a lot of lawyers. State courts have about 92 million cases a year. So again, state courts this is all over the country as well, state courts tend to have a little bit more of petty crimes, misdemeanors, things like that. Federal courts tend to deal with more serious crimes, and they might also deal with misdemeanors as well, but they mostly deal with very important high-level federal crimes. Courts must have jurisdiction to hear the case, so the authority to hear and decide a case is really important. The original court determines the facts of the case under the original jurisdiction. The appellate jurisdiction has the power to review and revise the decision of the lower court, as I said before. And there's certain categories between the two different types of law as well. There's civil law and there's criminal law. And civil law addresses the conduct or relations between private individuals and companies, and criminal law regulates the individual conduct and is enforced by the state. And a lot of civil cases deal with more monetary stuff sometimes. It also could depend on property, and criminal law deals with the direct conduct of each individual. Appointments to the Supreme Court. This is where things start to get interesting because they lay out a lot of qualifications you have to be president, to be a member of the Senate or the House. But they really don't lay out anything for the Supreme Court. And there's a reason why for that. Because the way that we look at law is very different from the way we looked at it back then. The Founding Fathers, some of them had law degrees, but those law degrees were not the rigorous study that you had to do today. It was pretty rigorous, don't get me wrong. But they were kind of making a Supreme Court system. So there wasn't any precedent where you needed to say, hey, maybe this person should have a law degree before they come in there. It was kind of hard to find that at that point. Sometimes that might have been a good idea to put something in there to say they needed to at least practice law or been a part of a judge, but they wanted to have people participate. And I think it was, they had trouble finding people as it was, and there was no qualifications for anybody to come in and be the Supreme Court justice. But now maybe there should be some discussion on maybe we should change this to make sure that somebody doesn't get in there who probably shouldn't be in there. There's a presumption, though, of intelligence and experience, especially now. The Senate is the ones who actually will vote in a Supreme Court justice. The president makes an appointment with the advice and consent of the Senate. And they appoint all Supreme Court justices and federal court justices as well. And mostly they have qualifications for judges, but to be on the Supreme Court, you do not need any. And any federal judge case, really, you don't either. But there have been very rare instances of somebody who has not had some experience in the law being appointed to the Supreme Court, especially in the last couple of years. Prior to the appointment, there's always an investigation into the background on the person, the rulings, their party, their beliefs, their character, their finances, their writing. And this is a couple years ago. This is what happened with Brett Kavanaugh. Brett Kavanaugh is one of the Supreme Court justices now, but he went through a vastly rigorous hearing that questioned his personal morality and really brought into question what he did in his youth. I mean, they went back 40 years and tried to see if there was something in this guy's past that he had done that was really horrific. But it's important because you need to really decide how this guy serves for life. And that's the other thing maybe I didn't make clear, that when you are appointed a Supreme Court justice, you serve on the court for life, that there's no term limit, that there's nothing that requires you to work only to a certain point. You can work until you die or until you retire, and that's really about it. The Supreme Court justices have done that before. Sandra Day O'Connor is a good example of this. She is a retired Supreme Court justice, the first woman to ever serve in the Supreme Court, but she retired, and she could have served and kept serving right now. Ruth Bader Ginsburg is a good example. She's 85, something like that. She's still on the court as of right now. Hopefully it stays that way. She's still on the court as of right now, and she is kicking it. I mean, they just really don't have to have any term limits. They can serve for as long as they want. That's why you tend to have guys that they choose who are in their 40s or 50s, so that they can serve for 30, 40 years. And this is so important because we are still feeling the effects of presidencies that have been out of office for 10, 20 years down the line. We still have appointments on the Supreme Court from Ronald Reagan. That is a long time ago. But Clinton's appointments are still on there. Ruth Bader Ginsburg and Stephen Breyer are good examples of that. George W. Bush has a couple of different ones. The Supreme Court Justice Roberts, is one of the people that George W. Bush put into power. We have 2 Obama ones as well, and now we have 2 Trump ones on top of that, and potentially even 3, depending on what happens in the future. But yeah, I mean, you feel the effects of these presidencies far after they have left office. And that is why a Supreme Court justice is such a big deal. They make considerations also into investigative results. They look into senators and states, attorney generals, and the American Bar Association as well. They look into how the American Bar Association views them as a lawyer or a judge. I mean, really, they look into this person's background, and they hammer on every single thing they have ever done in public and in private. It's just amazing. They'll look into anything into your life, but it's so important because you are having a lifetime appointment, and really this is something that a lot of people don't pay attention to until there is something like the Kavanaugh situation, who really, it's just amazing that he got through that, because that is a really horrific thing, and somehow he got through. So hearing a case, there's about 9,100 cases that come to the Supreme Court, but only about 88 per year actually get heard. About 66 of those cases are federal courts decisions, and then the 33% are from state Supreme Court decisions as well. Less than 5% are original jurisdiction cases. There could be disagreements between circuit courts are usually a priority. There's an application, a statement of jurisdiction. There's a clerk review, which means that they bring their clerks in. So all justices usually have clerks who review a majority of their cases. And there's a rule of 4. That means 4 justices must approve to hear the actual case. Cases must involve a federal question as well. So it needs to be a question of what is federal authority over this. Is there precedent set before this as well that falls under federal authority? Cases must present a question to the federal and constitutional law or be original jurisdiction as well. So it's got to bring questions to, does this fall under what has come before it, under the constitutional law or federal law that's already been established, or it must fall under some original jurisdiction that has never been tried before. Cases involving the U.S. government are usually handled by the Solicitor General, who's the 4th in the Department of Justice, so they will come to the Supreme Court and argue on behalf of the U.S. government. You may also have third parties come in who are called amicus curiae. They're the friends of the court. They might have an interest in the outcome of the case, whatever is brought up, and they raise issues to the court that the court might not be aware of or impact on areas of interest. And amicus briefs attempt to influence the court's decisions. So the internal process of how this all works is that there's a submission and application to the Supreme Court on a case that they might want to hear. The clerks usually confer with each other, so there's each individual justice will have a group of clerks that will look over the court briefings and will look and see if there's something that this might be something that might be of interest to the Supreme Court justice. There's a justice conference as well. So in order for something to be heard, 4 out of the 9 judges need to agree to hear the court case. So they might not agree with it. They'll certify that. They'll certify that that they actually want to bring the Supreme Court case to the actual court. There's a briefing, so you start to hear briefings and rebriefings of each court case. The Supreme Court justices become a little more familiar with it so they can ask questions. Then there's oral arguments, which is actually coming to the Supreme Court, and the Representatives of each case will come and present their arguments to the court. There's a conference of the judges, so after they've asked questions and done all that stuff, they'll come to a conference and they will decide where they stand on things. And they will decide on where kind of who wants to be in the majority, where the minority stand, and who wants to write the decisions of each court decision. And we'll talk about how they decide the opinions, and those decisions are then brought out to the entire United States. And usually it's a big deal when a Supreme Court case comes down, so that way people can hear what is actually going on in the court. The term of the Supreme Court usually begins by statute in the first Monday of October, and usually the court sessions continue until late June or early July. So it's a good couple months that they are sitting there actually listening to oral arguments. They will divide time between sittings, where the justice can hear the case and deliver opinions, and intervening recesses, where they consider the business before the court and write opinions. With rare exceptions, each side is allowed 30 minutes of argument, and up to 24 cases may be argued in one sitting. Since the majority of cases involve the review of a decision of some other court, there's no jury or witnesses are heard. So usually they just go off of the decisions that came before in the other Supreme Court cases or the other court cases, and they listen to what had been said before, and they are familiar with it. For each case, the court has before it a record of prior proceedings and printed briefings of the argument of each side. When the court is sitting, the public sessions promptly begin at 10 a.m. and conclude at noon, with occasional afternoon sessions as necessary. Opinions are typically released on Tuesday or Wednesday mornings on the third Monday of each sitting, when the court takes the bench, but no arguments are heard. The court maintains the schedule until a case is ready for submission, have been heard and decided. In May and June, the court sits only to announce orders and opinions, and the court recesses at the end of June, but the work of the justice is unceasing. During the summer, they continue to analyze new petitions for review, consider motions and applications, and make preparations for case schedules for fall argument. So this is a full schedule of what the court is like. They have this big cycle that they go through every year, and they will hear large, small Supreme Court cases. Sometimes we don't hear a lot about them, but they usually hand down about 2 or 3 Supreme Court case decisions that really make an impact on our laws. We just don't hear about them sometimes. So the way opinions are laid down is that the majority sets precedent and becomes the law. So that automatically the majority of Supreme Court justices who vote in favor of something, that automatically becomes the law of the land. You can also concur with something, so you can agree with the decision, but not the logic behind that decision. You could agree with the majority of the opinions, and you could vote for it, but you might not agree with the logic of the other justices. You might have something else why you voted yes for it. But then there's also the dissent as well. That means that the minority of voters, and they can have a disagreement, and that does not become law, but their opinion is still known of why they dissented from the majority. And those can be just as important as the majority opinion as well. While the majority is law, the dissenting opinion is still really important to making sure everyone understands why someone disagreed with it, and why a Supreme Court justice might look at this and be like, I don't agree with why they put this out there. I don't agree with this law, and I think this is horrible, and this is going to be really bad for our country. And those can be just as impactful as the majority opinion too. You could also have plurality as well. And this is really rare. This is where 3 or more justices support the opinion and becomes the controlling opinion without the majority. And this is not used as precedent, though. So people agreed with the majority, or what they would think would be the majority. It doesn't become precedent of law, if that makes sense. It's a really confusing idea, but plurality is one that's rare. It doesn't happen too often. The most important thing that I want you guys to remember is that there's majority concurring or dissenting. The Supreme Court justice decides who is going to assign the writing of the majority. So even if he doesn't agree with it, he decides who's going to write the majority. And usually the senior justice in the minority authors the dissenting opinion. And sometimes, mostly if the Supreme Court justice, especially if the Chief Justice is in the majority, he will sometimes write that opinion. But they might also give it to the person who's most senior in line of each decision. So seniority in the Supreme Court is really important as well. But that senior person can also hand it down to the other justices as well. Ellen Kagan, for example, is one of the younger judges now, but she is still third, I believe, third youngest, or third seniority, or like third to last, in seniority. The 2 newest guys, Neil Gorsuch, who was voted in by Trump, and Brett Kavanaugh, they're both in the lowest rung of the Supreme Court. So they have to work their way up in order for their opinions to be heard and kind of decide and have a bigger role in the Supreme Court. There's a lot of seniority that goes into being able to write opinions. They'll still get some, but it's mostly on cases that people won't read and won't be on big cases. Senior justices will usually write on big national story cases. They will write about it. So how do justices vote? And I mean, this really comes from kind of look past just who they are as individual party members. They kind of decide how they're going to vote based on how they look at the law. There's something called stare decisis, which means that really they just look at precedent of the law. What has come before that influences their decision? And this is why precedent is so important. They'll look at past laws and past Supreme Court cases and see stuff that is similar and make their opinion based off of those past Supreme Court cases. There's also legal factors as well. They might have a judicial philosophy. It's like the same thing of looking at the Bible in a literal sense compared to a metaphorical sense. That's the same way the justices can look at the law. Some of them look at the Constitution as a actual, like, whatever the Constitution says is what we should go by. Some of them decide that there's maybe some things that the Founding Fathers might have meant that they didn't put in here, but maybe we should make our own interpretation of it. So everyone has their own judicial philosophy that follows what they decide. There's extra legal factors as well, implementation and impact on society, that they could really decide, well, what kind of impact is this going to have on our society? So they might make a decision that might go against their personal beliefs, but they really do believe that they need to make the decision that is best for them best for us as a society. And there might be extra legal factors. I mean, this is why they look into the background of people so fervently, because their life experiences affect how they're going to vote on something. And this is really important because not only do you have to have, like, let's say that there's something about sexual assault case that comes to the Supreme Court. If Brett Kavanaugh, for example, has a decision that they find is in favor, that people might question his ability to make a decision on that. It really was probably a very hard experience for him to have to go through his whole life from 40 years ago. And that could really make a factor in how he votes on future cases. And that's why it's so important, because you need to know what these people have done before and what their life experiences are, because that might factor into how they vote on something like this. The justices will also take in public opinion. They'll look at public opinion, and I mean, they read the paper, they read stuff. They know what people are wanting and voting for. You can't really tell me that Justice Kennedy, who just retired like a year ago, he was so important to the passing and legalization of gay marriage. And I really look at his opinion, and he talks about the factors of public opinion and the impact on society that this is going to have. His decision was really well thought out, and that's what part of what I'm going to have you guys read. His majority opinion is so well written and very impactful into the entire look at political life and the role of the Supreme Court. I think it's beautifully written, and it's just something that I hope you guys get something out of it when you do read it. There's also judicial philosophy as well. There's activism, which is the expansion of rights from the bench to better society, or there's restraint, and that's respect for prior rulings, interpretations, and limited to intent, and not to legislate from the bench. So you have two different sides of the spectrum. This activism, which is like, well, we should help people expand their rights or protect their rights. And then there's restraint, which is, well, we shouldn't be legislating from the bench. We should be just interpreting what the law is supposed to be and should limit our power over that. With that, that is the judicial branch. And I really hope you guys got something out of this. This is something very different. I mean, this is kind of just the basics of the judicial branch. I love talking about this because this is something that a lot of people don't know a lot about. And I hope that this kind of gives you more perspective over what the Supreme Court is supposed to be like, why it's so impactful, and why it makes a difference in our society. We really don't know a lot about this. The average Americans don't know a lot about it. And the more that they learn about the Supreme Court, I find that the more that it becomes easier for them to understand and it makes them become more involved. If you know things about the Supreme Court, you know a lot more than the average American. And I think that that is extremely important to bettering our society and our function of government. So again, that's it. Hopefully, my plan is to also add a video where I go over the actual Supreme Court justices that are currently in place. The timing of this video, there might be different ones in from when I'm filming when you're looking at this. So I want to make sure that everybody kind of has an up-to-date idea of where our Supreme Court stands, who's on it, how they vote, how they think, how they feel, or at least the ideas that we get from the bench. I hope you guys have a good rest of your week. Let me know if you have any questions, and I will see you next week where we're going to be talking about the legislative branch, and that is one of the most important, if not the most important branch. And we're going to be talking about that and why it makes such an impact on our society. So, all right, guys, I will talk to you later. Have a good week, and I'll see you next time.